Good afternoon, everybody. This is again an extension, one more discussion around the Supreme Court decision in the case of Ashish Agarwal on revalidation of all the notices under Section 148. Much has been spoken about this, much has been written about this. Just a 2-minute background on what we are going to discuss. That there were a set of notices under the old law issued under 148 between 1st April and 30th June of 2021, which was really a period extended by the TOLA. And the question was whether these notices are valid because the law had changed from 1st April 21, and therefore any notice issued after that date ought to have been issued under the new law and not under the old law. On this point alone, there were a lot of High Court rulings which had held that the notices were bad in law, quashed those notices because they had the revenue had to follow the new law and not the old law. The Supreme Court, while agreeing with the High Court's decision and upholding in a sense the High Court decision to say that that's the right reading and the revenue ought to have followed the new law, interestingly restored all these notices by stating that these notices will be deemed to have been issued under the new law, and the consequences follow thereafter. So in one shot, what we hear is about 90,000 notices technically got revalidated. The Supreme Court ruling in that sense, other than revalidating these notices by stating that these will be deemed to have been issued under the new law, did not give further guidance on what needs to be done and only stated that the revenue is directed to follow the procedures and follow the new law. Now, between what was existing earlier and the new law, there are substantial changes on two counts. One is on the validity and where you can invoke the provisions of reopening. The second is on the timeline and how far back in time can you go. On the first bit, while under the old law, the officer should have had only a reason to believe that there is income escaping assessment, under the new law, he ought to have information which suggests that there is income escaping assessment, while income escaping assessment remains the same. Therefore, there was a basic threshold to be crossed that the officer should have had information. There is guidance thereafter as to what that information is and how the field has to obtain that and things like that. But for this intervening period of 3 months, where the tax officers believed that they had issued the notice under the old law, but now the Supreme Court says it's the new law, then there's this gap as to, how do you cross this new threshold of information and what needs to be given to the taxpayer. In terms of procedure, earlier he had to have reason to believe and he could reopen the assessment and thereafter the consequences followed. Of course, because of a Supreme Court ruling in GK and Rapshops, we had the Supreme Court had laid down certain things to state that the reasons have to be communicated. Thereafter, the SSE has a right to make submissions around that, etc., which is now being codified in law in the new law, which basically states that once that information is which suggests that there is income escaping assessment is available with the tax officer has to provide an opportunity of being heard to the SSE as to why this is not a fit case for reopening, and thereafter receive the objections of the SSE or a response. And within 30 days of receiving that response, if he believes it's a fit case for reopening, can then reopen the assessment and issue the 148. Therefore, before you actually reopen the assessment, there are these different thresholds and steps to be crossed. One is you have information, you put it to the SSE, seek his reply. Thereafter, you again apply your mind to see if it is a fit case, and then you reopen the assessment. Now, all that the Supreme Court had said is these will be deemed to be new notices, notices under the new law, and then the new procedure has to be followed. There was enough doubt in the taxpayers. There was also doubts in the tax officers, which was clear by the letter that one of the tax officers association had written to the CBDT, and which I thought was a beautifully drafted letter, had a lot of points practically what the officers would face in terms of what needs to be given to the taxpayer, how far back in time can they go, etc. So this was very clear that there was a need for certain instructions to be issued. On one, the procedural aspect, and second, equally important, on the legal aspect, on how far back in time can the tax officers go. Because earlier you had a time limit, without getting into too much details, of a 4 and 6 year period in different situations, and now it is 3 and 10. 3 years in certain situations, and you can go up to 10 in situations where there is assets which are not disclosed, and income escaping assessment is represented by that. How do you apply which test, and how far back in time can you go? So on these two aspects, there was doubts, and so the CBDT has now issued instructions, and this is instruction number 1 of 2022, dated 11th May. So yesterday they issued these instructions. Instructions are welcome on more counts than one. Firstly, I think it is it's commendable that they have done this in a short period of time, because what it will ensure, which is good for both the revenue and for the taxpayer, is there'll be uniformity in the approach taken by the tax officers. So each tax officer will not today sit and apply his own judgment on what needs to be done. How do you read some of these things? So to that extent, there'll be absolute consistency in the position taken by the tax officers across, because these instructions are binding on the tax officers. So they are, and I'll just get into what those instructions are. So there will be consistency, which both the taxpayers can expect and the tax officers will need to adhere to. And secondly, this gets into both the aspects, on the procedural aspects and even on the timeline. I'll first get into the procedural aspects. On procedural aspects, it's covered in para 8.1. It very clearly states that the Supreme Court has held that these would be notices under the new law, and there is a new requirement, and therefore, within 30 days, all the procedures have to be completed. And the CBDT actually states that you have to provide these reasons, provide opportunity of being heard to the taxpayer, and then await his response. And if in cases the taxpayer seeks additional time to furnish a response, and the officers have been permitted to give that, of course, the law also provides that. The CBDT has drawn attention of the tax officers to that clause to state that if in accordance with that there's an application made, you can permit them to file responses after the extended period. And therefore, today it's very clear as to by which time the tax officers will issue the notice, clear guidance to the tax officers to permit additional time. So we wouldn't have these situations where the tax officers will be not willing to give that time with a fear that there's a court given date, etc. Now there is a circular, there's an instruction, which backs their action. Therefore, they will provide these extended time. These become important because some of these go back in time, and records will not be easily available. So there will be time that will be required, and these replies are extremely important as we go forward in litigation, if you want to put all the facts, etc. Then that very interesting, and this is the most important thing on the procedures, is the CBDT instructions very clearly state that if it is a fit case for issue of 148, an order will be passed and served on the assessee. And they also state that if it is not a fit case to issue the notice, then the order passed to that effect shall be served on the assessee, which means to state that CBDT is clear that if those tests are not met, there need not be a mechanical, way of just validating these notices, accepting the reasons and issuing a 148. There needs to be an application of mind, and that needs to be documented. If for whatever reason it's not a fit case for issue of 148, then that also has to be issued. So from a procedural aspect, I think this is a good instruction, clears out most things, I would state, gives clear directions to the field on what needs to be done, gives certainty, and the taxpayers will know what to expect out of these proceedings. Coming to the timeline, which is where I think there are a few things which could have been clearer or better. There are two parts to this. One is the instruction very clearly says that these will have to be done for all cases, all notices, whether those notices have been challenged or not. So there were some doubts on this as to what happens to those cases where the notices were not challenged before the courts, even though 142 article was used and the decision of the Supreme Court was applicable pan-India even for pending cases before the High Courts, not just those which were decided, nor only those which were before the Supreme Court on appeal, but it applied to all cases. The instruction is clear, at least to the tax officers, and it's binding on them that it applies to all the cases. Second, in terms of timeline, again, two parts to it. One is cases where the income escaping assessment is expected to be less than 50 lakh rupees. In that, the CBDT very clearly states that in those cases, for assessment year 13, 14, 14, 15, and 15, 16. And I'm aware of multiple cases where notices for this has been issued. If the amount is less than 50 lakh rupees, in order to reduce the compliance burden of the SEC, it is clarified that the information and material may not be provided for these years if the income escaping is less than 50 lakh, and they say separate instruction will be issued regarding procedure for disposing these cases. Now, what they'll come up with there, we'll have to wait and see, but at least they have clearly recognized that there is this situation where it is beyond the 3-year period for certain cases below 50 lakh rupees. On the other cases, they've actually said that, that you provide the information that is prescribed under 149(1), which is there. Now, there is not too much guidance on what the officers have to provide, and that probably could have been something that the CBDT could have done in terms of giving some guidance to the tax officers, because you remember that these are notices which, when the tax officers issued, believed that they had to comply with the old law, and therefore they would have only checked reason to believe. They may not have those information, etc., which suggests that there is income escaping assessment for us, for that to be provided to the taxpayer. So here there could be certain situation and cases where the taxpayers may or may not agree with the positions taken by the tax officers. Two very important things to remember here. One, the Supreme Court very clearly states that all defenses available to the taxpayer under 149 will still be available, and so therefore we could challenge these notices. Second, and equally important, is whatever these instructions are and issued by the CBDT are binding on the tax authorities. They are not binding on the courts, nor are they binding on the taxpayers. Therefore, even if some of the taxpayers believe that what the revenue is doing on these cases where there is not much clarity on what that information is, and if there is doubt that those information, whether they meet the tests or not, the legal remedies will still be open, irrespective of what the instruction says, including on the timeline, including on whether they are time barred, not time barred, whether it goes back in time or not, can still be challenged. That's a very important aspect to be remembered. Then there's one very technical point here, which is for particularly assessment year 13-14, which could not have been issued if the timeline was 31st March 2020, because it was 6 years at that point. Therefore, you couldn't have gone back to 13-14. Now, whatever could have been done by 31st March 2020 was extended up to 31st March 2021 with various extensions of the TOLA, and thereafter till 30th June. So the tax officers at that point believed that since the old law had extended, therefore until 30th June 2021, they could still reopen 13-14, which was 6 years before 31st March 2020. Now, what the Supreme Court says is that these notices are deemed to be notices under the new law. They are not notices under the old law, which are enjoying an extension under the the TOLA. Therefore, if they are the new law, there is a proviso to section 149, which says that you cannot reopen something which could not have been reopened under the old law, which is that beyond that, which is that 6th year. Therefore, in my view, on 13-14, probably there lies an ability to challenge validity, even if an officer issues notices and proceeds further on 13-14 following the instruction. And like I said, these instructions will be binding on the tax officer, not binding on the taxpayer. That could be challenged. So overall, if I have to sum up, the instructions are welcome in a sense that they create consistency, in a sense that they clearly lay out what the procedures have to be followed. But in terms of the timelines, in terms of which years they can reopen, etc., I think there are aspects, and it's too technical to cover in a brief discussion on this. There are aspects where on time barring, there will still be legal remedies available. And even if the officers follow what is there in the instructions, it may actually not be in accordance with the provisions of the new law. And if it is not, in our view, that challenge lies. So that's sort of a quick summary of this instruction which has been issued yesterday. Thank you.